All right, Mr. Church, are you able to hear me okay?
Yes, Your Honor.
See, Mr. Love's connected here, so Mr. Love, I need you to turn on your.
I didn't know who was going to go first. So.
Turn on your microphone and your camera, please, and unmute. Okay. All right. Before we get started this morning, we are conducting here in Crawford County a public satisfaction survey. So anybody who's joining by video or in the courtroom, I encourage everyone to log on to the survey or complete it here in the courtroom in person. That being said, Mr. Love, are you able to hear me okay?
Yes.
All right, we'll go on the record in People versus Love, file number 255486. Mr. Love is appearing today by prior approval of the court by video, and if I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Love. Your Honor, I think this is set for a final status conference prior to a trial that was scheduled, I think, to begin next week. A few weeks ago, I reached out to the prosecutor as well as your staff and let them know that we had an agreement that was going to resolve this case as well as a pair of cases over in Otsego County. We asked the clerk to schedule the Otsego cases for a plea, which I think is scheduled for next month. We intend to enter into an agreement here where he would be admitting to possession of methamphetamine without enhancement. And we would ask the court to give us about 60 days for the sentencing so that we can line it up with Otsego and have all of that happen effectively in the same week.
All right, Ms. Koch, is that a correct statement of the plea offer?
It is a correct statement of the offer. When the court wants to do sentencing, I defer to the court because most likely he's going to get an MDOC sentence. And I'm not sure how the court wants to schedule those two things, but that is a correct statement of the offer. It also includes the not charging of a new case that we have. We actually charged it and dismissed it. And that was part of the plea agreement.
Okay, but you don't have a specific objection to the court scheduling sentencing as requested by defense?
I would just defer to the court as to whatever's the most convenient for the court. It's not, I don't object. I just don't know that that's the right answer.
All right. So I guess, Mr. Trush, tell me again, I mean, the Otsego case, what difference would it make for sentencing in this case versus the Otsego case, and why would it be more efficient to do it that way?
So, Your Honor, I think there's two reasons why it would be more efficient to do it. One of which obviously is we know how quarantine often works. If we do the plea here and have him sentenced here, presumably next month, I think we run into a problem of, are we going to be able to have him available to do the plea there? And then are we going to run into issues of getting him there for the sentencing in Otsego because he's likely still going to be in quarantine? It would seem to me, if we lined it up the way I said, I think we could conduct both sentencing hearings effectively at the same time, or a day apart. I mean, if we had the sentencing in Otsego on Wednesday and then Crawford County's on Thursday morning, I think we could have it all done effectively with one shot, as opposed to having to have them transported potentially twice to get it all done.
Okay. All right. Mr. Love, have you been able to hear what we said regarding the terms of the plea agreement?
Yes, I have.
Have you discussed those terms with Mr. Trush?
Yes.
And did you want to proceed with that plea here today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Love, you understand that the charge you're going to be pleading to, which is possession of methamphetamine, carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine?
Yes.
Are you currently on any kind of probation or parole that's going to be violated by your plea here today?
No.
Okay. Then with that maximum penalty in mind, what is your plea to that charge?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
I do.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. And that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here on the record today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this crime?
Yes.
The information I have indicates this happened back on August 8th of 2025. Is that the correct date?
Yes.
On that date, were you present here in Crawford County?
Yes.
And while you were here in Crawford County, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No.
Ms. Coker, are the people satisfied with the factual basis?
Yes.
Mr. Trush?
Yes, Your Honor.
Ms. Coker, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Trush?
I'm aware of none.
And Ms. Coker, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Trush?
Yes, Your Honor.
Mr. Love, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for sentencing in 60 days. And Mr. McFelda, can he call you to attach to?
If he could provide his phone number, I would prefer that.
All right, Mr. Love, can you give us a number where you can be contacted?
Yeah, 989-745-3406.
So, Mr. Love, it's important that you follow up with the probation department when they contact you.
Yep.
And that you stay in touch with your attorney prior to sentencing. Based on the plea today, the court will adjourn the trial currently scheduled for March 12th. Mr. Trush, is there anything further we need to address from your side?
No, Your Honor.
Mr. Love, do you have any questions?
I do not.
Okay, thank you. That's all for today. And Mr. Love, you're free to disconnect at this time.
Okay. Thank you, Judge.
Mr. Roby, is one of you Mr. Roby? Okay, Mr. Roby, if you can come up to the podium there, please. We'll go on the record in People versus Roby. This is file number 265520. The record should reflect Mr. Roby present here in the courtroom today. Mr. Trush, can you tell me the status of this file?
Yes, thank you, Your Honor. In this file, we're going to be asking for a 30-day adjournment here. We've been in negotiations with the prosecutor. There is a global offer that contemplates resolving a couple misdemeanor matters as well as this. We're not quite there yet, but I would say we're most of the way there. Might not be in the same row, but we're certainly in the same section of the stadium, so to speak. And again, I think with 30 more days, we likely would be able to get it done. I would like to address a bond issue to the court, though, as well.
Okay, what is the bond request?
Your Honor, I think the bond is set in this matter at $50,000 cash or surety. I would ask the court to consider a slight reduction here. Mr. Roby has been accepted into the Lion's Den program for treatment. He is working on getting his bond posted here, and the $50,000 bond is an impediment to that. I would suggest to the court, even if we reduced it to a $30,000 cash or surety bond, I think he would likely be able to make that. And again, I think that's still a significant bond that would give him a significant incentive to appear for court and do the things he's supposed to do. Additionally, keeping in mind, the court could put a condition into the bond, for the treatment program, which would give an additional sort of layer of sort of supervision or protection to the court. Thank you.
Mr. Trush, based on what you think at this point would be a likely, if there is a plea agreement, what would be a likely guideline range? Have you looked at that?
So I have, Your Honor, and that's part of what we're working on is clearing up some of the prior history. It's likely going to be either a straddle cell. So I've had it come out at 5 to 23 or 10 to 23 based on the some different scoring factors. I think it could come out as high as and I'm sorry, I don't have the book in front of me, but the low end could come out as high as 19, again, depending on some of those scoring factors. Again, with the anticipated or the offer as it stands right now.
All right, thank you. Ms. Coe, first of all, do you have any objection to the adjournment for 30 days?
No, but I will pull the plea offer at the next hearing.
Okay, and then in terms of the bond modification?
Yeah, I think the bond is appropriately sent. That Mr. Roby had a domestic violence case when this case happened. I believe he was on bond. Mr. Trush can correct me if I have the order of the cases wrong. It was a pretty violent criminal act according to the police report. I can read what the police report said, but it was bad. The victim wants the defendant to get help, but he has a pretty lengthy criminal history, includes a 2006 felony BE, 2010 DWLS, a 2010 marijuana, a 2010 negligent homicide, a 2019 DWLS, a 2019 DWLS, and a 2019 possession of methamphetamine. I pulled his PRVs on his last Ross Common felony case, and they were 70. So I expect the guidelines to be fairly high. The offer is assault by strangulation, domestic violence, dismiss the aggravated stalking and habituals, dismiss the other DV, and dismiss the DWLS.
Okay. All right. So, I mean, Mr. Roby, if the only reason for the modification of bond is so that you can get out and go to compliance, then I'm not opposed to treatment, but it sounds like your guidelines are going to score out at a minimum for some jail time. Okay. It doesn't make sense to me to have you be released, go into the lion's den for a month, and then be sentenced to jail and have to leave that program.
Actually, sir, there's a bond that is revoked right now that we actually needed reinstated, was actually what he was supposed to ask you about. And we sat down yesterday with my lien file. And
Mr. Roby, the bond that's revoked is the district court bond that we have to address Tuesday. I plan to come over and talk to you about that today, but that's up in front of the court on Tuesday the 10th. So next Tuesday.
Oh, so we can't do anything about that till next week?
No. I stop you because I don't really want you to talk about our conversation.
Okay. Well, I didn't know about that, sir. I'm sorry you weren't here in person to talk about it. Okay, I'm sorry. Well, we discussed my lien file yesterday and looked through it, and it scored me out. He said he was confident 5 to 23 months, which would be about a county year. I'm trying to go to the lion's den for minimum of a year. I have a really bad drinking problem, sir. I really, really want this help, and I need this help. You can look at my file. I have a problem with alcohol and drugs, sir. I have a problem. I need help. I really care about this individual that I hurt, and I can't keep going through life like this, sir. I cannot do this. I need help.
Yeah.
I have been accepted into the lion's den. They have a bed waiting for me. I have transportation there. I have the money that they want to seed money or whatever they want, like $65. I have that money set aside. Somebody's got it for me. I need this help, sir.
Yeah.
I have no intentions on walking away. I don't have any, and there's a blackout period where I don't get contact anybody for like 3 months or 4 months or whatever. With exception, they bring me to my court dates. You know what I'm saying? There's no missing court dates. They're bringing me to my court dates. I need this help, sir. I really need this help. Honestly, you could say, all right, straight to the lines then. And I have a vehicle pick me up and take me straight there today. And then there's no skipping around. Otherwise, it's me trying to make a bond next week. And then, okay, well, I got until sentencing to get there. Well, I'm not doing that, obviously. I'm just trying to go to the lines then, sir. I very seriously need this help. I have a drinking problem. You weren't in here, but Mr. McCall's like, damn, I didn't even notice you. I'm losing a lot of weight. I've been self-destruct for the last year. My grandmother died, the only person in my family that cared about. I've been in self-destruct mode. You heard Miss Cope. I hurt somebody that I really care about. I'm not doing good, sir. I really, really need this help.
Yeah.
Okay.
I'm not doubting that at all. The question is, when is the right time for you to get that help?
Well,
And
that's
you have
the
to
thing.
answer for these charges first.
I understand,
Then
sir.
we can move on to the treatment part of it, and it doesn't make sense to do those out of order to me. I'm not going to do those out of order.
Okay.
Once we get this taken care of, if you're gonna have a jail sentence, you serve your jail time, and then you can go to treatment. The line's done, you can go anywhere. But you can't do the treatment and then the jail. Any treatment facility will tell you that that's counterproductive to go into treatment and then go back to jail.
Erase the treatment part of my sentence.
Maybe, yeah. But I'm not gonna let you out of jail now by lowering your bond to go into treatment, have you come back, go back to jail.
Can you modify my bond to send me straight there? They will send a car to pick me up.
What I just said is, we're not gonna have you go into treatment and then come back and then potentially serve a jail sentence.
Okay.
So it may be part of the sentence once we get to that point. If we have a plea,
Okay.
or if you're found guilty at a trial,
Okay.
then we can look at that as part of the sentencing. And I always do ask anybody, I'm not opposed to making treatment part of a sentence. It doesn't make sense to put the cart before the horse. So
I understand.
if that's the only reason for the modification bond, I'm going to deny that request. I'll absolutely consider lines then as part of your sentence if you're found guilty or you plead guilty.
Appreciate that, sir. I really, really need this help.
Okay. All right. So we're going to adjourn this for 30 days. Mr. Trush will be in touch with you, it sounds like, later today to talk about this case and your other case.
Thank you, sir.
Okay. Mr. Belvat, if you come forward, please. We'll go on the record. Belvat, this is file number 255369. Belvat present here in the courtroom today.
Your Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Michael Belvat. Your Honor, I did speak with Mr. Belvat. It's my understanding he does wish to plead guilty to the probation violation. I spoke with Mr. McFall. It's my understanding that he's going to have a recommendation of 12 months total. That Mr. Belvat has a bit of credit towards that and an unsuccessful discharge.
Mr. McFarland, can you leave a record of how much credit?
That's correct, Judge. He is 253 days served as of yesterday.
So in terms of credit, Mr. McFarland, does that include the time in Wisconsin? Or should I address that with the court?
That does not include that time.
Okay, thank you.
Mr. Belvat, have you had a chance to talk to Mr. Thompson about this agreement?
Yes, sir.
Okay, and you understand what the recommended sentence is?
Yes, sir.
I'm likely to agree and go along with that.
Yes, sir.
Okay. So with that in mind, what is your plea to the probation violation?
Guilty as charged.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
With all that, you understand that you do have the right to have a hearing as to whether or not you violated your probation,
Yes.
and that by pleading guilty, you're going to be giving up that right.
Yes.
Also, even though we've discussed what the likely sentence would be, by pleading guilty, it could subject you to the maximum possible penalty on your underlying charge of OWI third, which is up to 5 years. Do you understand that?
Yes, I do.
And with all of that in mind, it's your intention to plead guilty today?
Yes, sir.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anybody promised you anything other than what we've just talked about?
No, sir.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you did violate your probation?
Yes, I did.
Back on February 16th of 2026, were you on probation out of Crawford County?
Yes.
Were you aware that one of the conditions of your probation was that you were to not use or possess any alcohol?
Yes.
And did you use alcohol on that date?
Yes, I did.
All right, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation. The court will accept the guilty plea. And you don't have an objection to going forward with the sentencing here today?
Yes.
That's correct, Your Honor. It's our request to do immediate sentencing and to waive our right to updated PSI.
Okay. Mr. McFall, other than what you've already stated, do you have anything you'd like to state in terms of his performance on probation or sentencing?
No objection.
Ms. Coe?
No.
Your Honor, I would ask the court to consider the time he's already served. In addition, Mr. Belvat can address this, but he advises me he did approximately 5 days in Wisconsin when he first violated before he was transported here. He's asking the court to credit that. I think Mr. McFall's recommendation is appropriate. Mr. Belvat had a relapse. He has recognized that relapse. I think he's going to address the court about how he understands this is a further reminder he needs to work his program. He had some upsetting life events, broke up with a long-term partner. He didn't handle it correctly. He understands that now with some reflection, he shouldn't have turned to alcohol. He didn't drive here, which I think is a point in his favor. And obviously we got here because of a driving offense. He did use alcohol. He's very apologetic about that, but this could have been worse and he didn't drive. So ask the court to take all that into consideration. Thank you.
Thank you. Mr. Belvat, anything you want to say today?
No, sir.
I did have a chance to review your file prior to the hearing today, just to refamiliarize myself with your case and the circumstances that led to your probation. I've gotten some information here today also about how probation's gone and your violation. I do think that the recommendation by Agent McDowell is an appropriate recommendation. I follow that. The court is going to sentence you to 12 months in the Crawford County Jail. The credit that you're entitled to is 253 days. The court, by statute, is not required to take into account any other time it may have served, and frankly, I think probably deserved. So I'm not going to give credit for the time I'm entitled to. But I am going to give you every day that you're entitled to here. It's 253 days. The court is going to preserve any outstanding fines or costs and discharge you unsuccessfully from your probation. You do have the right to appeal the sentence, and Mr. Thompson is going to provide you with some papers that explain to you what your appellate rights are.
Mr. Belvat, you're going to initial here. This indicates that you've received it. You're going to end up with 2 of these copies. If you wish to file an appeal, you would use these 2 copies. You can both ask for an attorney and file an appeal with them. The first deadline is in 14 days. You don't have to make your decision right now, but those are the documents.
Next matter, set for 9:30. Versus Trombly. My understanding, Mr. Thompson, Mr. Trombly was released from Montana yesterday.
It would have been, it was last week.
Oh, last week.
Yeah.
I just got a message saying he went to go pick him up on the written, he was released.
He was released last week. I do have, he met with probation over there at his release, and he was informed, according to the notes from the agent, Doug Cho over there, of this date and time of this hearing today.
It says he was released on 2/22 for prosecutor's office.
But I had no good phone number for him, so I couldn't just remind him again, but he was told about this date and time for his hearing.
Okay, did he contact you at all?
I have spoken to him before 2/22 about this hearing. I've not spoken to him since 2/22.
Well, it's 9:29, so we'll take a short break. We'll see if Mr. Trombly appears. If he doesn't, then we'll go forward.
No,
Any challenges to this morning?
no.
Anything on behalf of the people for allocution today?
This case is a struggle because I see the recommendation for rehabilitation, but the fact is, Ms. Leland's had the chance for rehabilitation throughout her whole life. I mean, we've been dealing with Miss Leal's addictions and criminal history, I mean, pretty regularly. I mean, she's only 39 years old. She has 7 felonies, 6 misdemeanors, and a juvenile record. You know, everything from tampering to, you know, what we have here with contraband in the jail, maintaining a drug house. It just goes on and on and on. I think the recommendation is appropriate because she's earned that, but I do hope that when she, if the court gives her an MDOC sanction, when she gets out, she actually thinks to herself, maybe I need to get into these programs without the court forcing me to, because I actually need these programs. She looks better than she does. I mean, she's pretty easy to tell when she's on meth, and it's just been an ongoing problem with her. So I hope she takes this seriously, and I hope the court follows the recommendation. Thank you.
Your Honor, Ms. Leland's 39 years of age. The court is aware of her criminal history. She has 6 prior misdemeanors, 7 felonies, majority of them all drug related. I think everybody here in the courtroom would agree Ms. Leland looks a lot better. She's feeling healthier, and part of it is she's sober enough on the drugs. Ms. Leland took some initiatives to engage in treatment, reached out to Catholic Human Services. She did get a acceptance to the lines then, and what Ms. Leland is requesting the court is to not incarcerate or send her to prison, but deviate downwards. The guidelines are what they are. She's on those guidelines, but give her a chance to complete a long inpatient treatment at the lines. Then it lasts about a 9-month program. And if she's successful, to hold any jail time or any other incarceration remains. If the court were to sentence Ms. Lee to a prison sentence, she would ask for the court sentence and then to the lower end of the guidelines. So Ms. Lee could at least take advantage of getting out early and getting back with her sobriety and maintaining sobriety. Thank you.
Thank you, Ms. Leo. Anything you wanted to say? Yeah.
Yes, Your Honor. First, I'd like to apologize. I'm sorry I'm in front of you again. I know that I have a really lengthy criminal record, but like, I didn't know until I met this peer recovery coach that I could actually use all of like my drug experience and my trauma and stuff to become a recovery coach like her. In the Lions, then they actually offer a program after the 9 months for another 10 months to train to be a recovery coach. And that's what I was hoping to do. I was hoping to maybe get like a county year and then do the 1.5 years at the Lions thing.
All right, Ms. Leo, I did read through the report, so I'm familiar with the circumstances that led to the charges in this particular case. I'm familiar with your background in this, and the information in the report about that as well. So I'm fully versed in all of that information. I take all of that into account along with what the lawyers had to say here and what you had to say. I don't think anybody doubts the fact that you do need to get into a treatment program at some point. That's the only way that you're going to be able to move on from this. It's pretty clear that everything that you've done up to this point hasn't worked. Everything the court's done in terms of probation, talked to Belvat, he's indicated he's tried to get you into treatment before. You either haven't gone or it hasn't worked. So I do think that's something that you need to continue to seek out if you want to stay out of jail or prison. Unfortunately, at this point where you're at, that's really not an option for me. As Mr. Herbert indicated, I would have to depart downward, and I have to have good reasons for departing downward. Here, unfortunately, just your expression of a willingness to go to a place like the Lions Den isn't enough of a reason legally for me to go below the guidelines in this case. And frankly, I don't see anything that's gone on in the past that would indicate to me that giving you that opportunity at this point would be worth the risk to the community and the risk that you would go back out and engage in helping other people get meth and treating yourself and other substances are even more dangerous. So I I don't think there's any reason why you can't seek out a program like Lions then. It's still gonna be there when you're done serving your sentence. There's no reason, just like Ms. Cope said. You have to wait for the court to order you to do that. You can do it at any time that you want. And so if you're serious about it, I hope you can follow through with that. As it is in this case, I do think that a recommendation, or I'm sorry, a sentence, particularly on your most serious charge, which calls for up to almost 5 years in prison. I think a sentence in the lower third of those guidelines, which would put you, in the mid to upper range in your other sentences, which are lower guidelines, I think is appropriate given all the circumstances here. So as to file number 5514, count 1, possession of methamphetamine. Court will order that you serve a sentence of 36 months to 20 years. Because of your status being on parole at the time, you are entitled to 0 credit. And that sentence to be served consecutive to any parole violation sanction. The court will order a crime victim's assessment of $130, court costs of $325, attorney fees of $250, DNA testing fee of $60, and a $204 state cost. On that file as to count 2, possessing contraband in the jail. Court will sentence you to 24 months to 10 years. Again, credit for 0 days served. That to be served concurrent with count 1, but consecutive to any parole violation sanction. Count 3, maintaining a drug house. 24 months to 4 years. Credit for 0 days served, so to be served concurrent to counts 1 and 2, but consecutive to any parole violation sanction. You do have the ability to seek an appeal of the sentence. Provided Ms. Leal with her appellate records.
Yes, Ms. Leeds acknowledged her appellate paperwork.
Mr. Thompson, did you have Mr. Jackson present?
Yes.
Okay. We'll call People versus Christopher Jackson, file number 255496.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Christopher Jackson. Your Honor, we were here on January 8th. I had placed a request on the record to have lab reports in this matter. Those still aren't in. I got a message on February 23rd that they were about to be sent to the lab. So from our perspective, that's hindered our ability to engage in plea discussion or be prepared for trial. But we're asking the court to set this matter for trial at this point, probably with the final status conference.
Ms. Cope, how much time do you need to be ready for a trial in this case?
We'd ask for 60 days.
Is that enough time, Mr. Thompson?
Yes.
We'll set it for a 60-day jury trial. Ms. Cope, is 1 day enough?
Yes.
Yes.
Set up for a 1-day jury trial, about 60 days out. I think I have. So as a practical matter, it's probably going to be June for trial date, just because I have.
All right, I'm out the last week of May, so that's fine.
Okay. So the court will set it for a final status conference prior to the trial date. Ms. Cope, are you anticipating any motions in this case?
No.
No.
So Mr. Jackson, you're going to get a notice of the date and time of your trial date. And then we'll have one final hearing before that trial date. To the extent that you want to consider any plea offers, that would be the last date to enter into a plea. So it's important that you stay in touch with Mr. Thompson and that you're ready with a final decision on that.
And Your Honor, that does remind me, I'm asking the court to update Mr. Jackson's mailing address.
Okay.
3414 Chambers Street, Flint, Michigan, 48507.
That is the address I have.
Okay, all right, thank you.
Yeah, I had recently moved back.
Okay, yeah, because I haven't received any mail back, but, yeah, that is the address I
All
have.
right, thank you.
Okay.
Okay, thank you, Your Honor.
Mr. Jackson, do you have any questions about how we're going to proceed with your case?
No, sir.
Okay. Thank you. That's all. And, Mr. Trombly, if you'd like to come forward. Go back on the record in Mr. Trombley's case. Mr. Thompson, how did?
Mr. Trombly intended to plead guilty to count 4, violation of state law, which is a non-technical violation. And that's based on the plea he tendered in Roscommon, which was to an attempted assault.
Okay, so Mr. Trombly, you've had a chance to talk to Mr. Thompson.
Yeah, Your Honor.
Did you want to move forward with that plea today? Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Mr. Trombly, you understand that you have the right to have a hearing as to whether or not you violated your probation?
Yeah.
You understand that by pleading guilty, you're going to be giving up that right?
Yes.
Also, by pleading guilty, it could subject you to the maximum possible penalty on your underlying charge, which is possession of methamphetamine, and that's up to 10 years. You understand that? Yeah. All of that in mind, what is your plea to the probation violation today?
Guilty.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anybody promised you anything other than what we said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you did violate your probation? Yes. On or about November 6th of 2025, were you on probation here in Crawford County?
Right. I'm not sure if it was here or Roscommon.
You might have been supervised in Roscommon, but your probation was here in Crawford.
Yeah.
And were you aware that one of the conditions of your probation was that you were to not violate any laws of the state of Michigan?
Yes.
Did you violate a law of the state of Michigan by pleading guilty to, what was it, attempted resisting obstruction?
Yes.
The court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged. The court will, that count 4, the court will accept your guilty plea to that count. We're going to set this for a probation violation sentencing hearing. You'll be notified of the date and time of that hearing. You're gonna meet with Mr. Belvat here today.
Yeah, why don't you provide a good address for the court? Make sure you get notice.
106 South 2nd Street.
Okay, thank you.
Mr. Trombly, it's important that you stay in touch with Mr. Thompson prior to that hearing, okay?
Will do.
Thank you.
Thank you.
Mr. Thompson, do you have Mr. Is it Quack?
I received a message that Mr. Quack was running late. I don't see him in the courtroom yet. Ask the court to pass that matter for a couple minutes. Thank you.
Are you ready for Ms. Leland once we have her brought up? What?
She's on her way.
It's on her way. Okay.
I'd like to speak to her in the hallway. If I could.
Is Mr. Phillips here?
Mr. Phillips is here, we're ready.
Okay. Let's take,
After we're done with the changes, assuming that Mr. Phillips.
we'll call People versus Anthony Phillips, file number 265522. The record should reflect Mr. Phillips is present here in the courtroom today. I could have counsel put the appearances on.
Sierra Coke on behalf of the people.
Thank you, Madam President. I think Terry on behalf of Mr. Phillips is just standing to my left.
Okay, so Mr. Gurmurthy, I understand that we have a no contest plea.
I do, Your Honor. The reason for the no contest plea is lack of memory and degree of inebriation. Mr. Phillips does not recall the events. I did submit a police report. I think that establishes factual basis I did submit the lab results as well. It's 0.24, and I stipulate to its use as well to support both the no contest plea and the count 3 plea.
Let's go. Do people have any objection to the court taking a no contest plea? For the reasons stated?
Yeah.
Yes, I will send it to you in a second, Sarah. I'm gonna pull it up.
And what is it again? I'm sorry.
No, we count 3 operating on intoxicated and it count 5. The code for that is 257.60282.
Yep, that's correct.
So misdemeanor OWI.
Yes, 93 to misdemeanor, and then a 2-year felony on fleeing route in 4th degree. Counts 1, 2, and 4 will be dismissed.
All right. Mr. Phillips, have you had an adequate opportunity to speak with your attorney about this agreement?
Yes.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Phillips, are you on any kind of probation or parole?
As of right now, no.
Okay. And you understand that by pleading guilty to count 3, which is operating while intoxicated, that's a misdemeanor that carries with it a maximum possible penalty of up to 93 days in jail and or a $500 fine.
Yes.
And that pleading guilty to fleeing and eluding 4th degree is a felony that carries with it a maximum penalty of up to 2 years. With those penalties in mind, what is your plea to those 2 charges today?
No contest.
All right, are you pleading no contest because you don't have a memory of this incident based on your intoxication?
Yes.
I'll go through your rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes.
You understand that you're going to be giving up and waiving all of those rights by pleading no contest?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You only do that by leave, and that means you would have to ask for the Court of Appeals to hear your case. If they said no, that would be the end of any appeal.
Yes.
Does anyone threaten you with anything to get you to plead no contest?
No.
Has anybody promised you anything other than what we said here in court today? That your own free choice to enter this plea?
Yes.
Folks, have you reviewed the police report, Crawford County Sheriff's Department report number 2512000, and that's 976?
Yes,
And the information contained in that report would provide a factual basis for finding that's the count 3 and added count 5.
yes,
Done that?
Yes, and I agree.
The court is going to mark and admit that exhibit as Court Exhibit 1 and use that as the factual basis. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
no, Your Honor.
Mr. Gerber, do you?
No.
Ms. Koch, are the people satisfied that the court has complied with statute, the court will take this plea?
Yes, Your Honor.
I would agree to.
Thank you. Mr. Phillips, the court finds that your plea is knowing and voluntary. I'm satisfied based on my review of Court Exhibit 1 that there is a sufficient factual basis to support a finding that you are guilty of each of these charges. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Germer prior to that hearing. You're prepared to go forward. Before you leave today, you're going to meet with Mr. Belvat to set up a pre-sentence interview.
Okay.
That's all for you. Thank you.
Just the only thing is, I did provide Mr. McFadden a copy of my client's substance use assessment. I just asked that that be attached to the pre-sentence report. I think it's required by statute for the OWI conviction, so.
Yes.
So
Okay.
we'll just attach it to the PSI. Thank you.
Yes, thank you. Ready, Ms. Leland?
Yes.
Ms. Leland, if you come up to the podium here, please. Go on the record in People versus Kimberly Leland. This is file number 245281. The record should reflect Ms. Leland's present here in the courtroom today.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Kimberly Leland.
All right, this is the date and time set for sentencing on Ms. Leland's probation violation. Ms. Leland, did you have a chance to go through the pre-sentence report with Mr. Thompson?
Yes.
Mr. Thompson, are there any additional solutions or corrections?
Your Honor, not additions, deletions, or corrections. She did have some comments about some of the reasons behind some of the things.
Ms. Coe, any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, it's not that often that we have people fail this swiftly and this terribly on when they're given a chance for a 7411. And she doesn't have any criminal history. Her husband is up for sentencing today. The court's aware of the circumstances of her charge. She got a very, very good break, a very good plea offer. The court was very lenient on her sentencing. We gave her every chance we could based on her minimal criminal history and her husband's criminal history and the amount of methamphetamine they had in the vehicle. We talked about whether or not there was a likelihood she knew all that methamphetamine was in the vehicle, and she only got sentenced on the methamphetamine on her person. I think a high end of her guidelines is appropriate. I think the revocation of her 7411 is appropriate. Frankly, had she been charged originally, she'd have been looking at a significant prison sentence. She quite clearly did not take this seriously at all. Thank you.
Mr. Thompson.
Your Honor, I guess I would take a different approach. I think Ms. Leland was charged and pled appropriately because I don't think the higher volume that she had anything to do with that. Quite frankly, I don't think anything about her relapsing changes that. She has a problem. She has a problem with controlled substances. I don't think that makes her a dealer. I think that makes her an addict who's struggling. And I think that's what's written all over this is a struggle. One of the things she did want to say is that she believes she had been to 2 to 4 treatments, that she had missed several because of doctor's appointments and some other reasons. She also relapsed, Your Honor. Her father died. She relapsed. She failed several drug tests. She has a problem and she's not on top of it yet, and she is still relapsing. So she understands that she did not live up to the terms of her probation. She understands that her addiction is even stronger than she thought it was, that the attitude and the approach and the strategies she was using to try to stay on top of it weren't enough. When her father died, she, was weak and she used. So she certainly apologizes for that, Your Honor. She understands that she is subject to a penalty today. What she told me is she kind of gave up when her dad died, and I think she is going to use this time that the court gives her to reflect on, going back at it, taking a better attitude, taking a better approach, and hopefully getting better results next time. So we understand the 7411 is likely to be revoked. We're just asking the court to take all that into consideration of fashioning a sentence. I would suggest 3 to 6 months would be an appropriate sentence. Thank you.
Thank you, Ms. Leland. Anything you wanted to say today? Sorry,
No.
Okay. All right, Ms. Leland, I did read through the pre-sentence report, so I'm familiar with kind of what happened during your brief term of probation. And of course, I'm familiar with the underlying circumstances of your case. I've got your husband for sentencing here today. And I was familiar with your case, the original pre-sentence report. And I think the hope was, well, first of all, sorry to hear your father passed. That's a difficult thing for anybody to deal with at this stage of life. And particularly for somebody who has substance abuse issues, it's easy to fall back to that pattern and have something like that happen in your life. So I'm sorry to hear that. think the hope was during the original sentencing was that we were going to place you on probation. Didn't give you any additional jail time at that point. You were released with time served, and the hope was that through probation you were going to get some help and deal with this and successfully complete probation. That clearly did not happen. In spite of what was going on in your personal life, seeing things like intensive outpatient treatment that you were referred to, peer support, individual sessions that you would have been available or had the chance to attend. Those are all things that could have helped you with father's death and with your underlying problems that helped you prevent a relapse. And I know you're contesting how many you went to or didn't go to. I tend to believe the writer of the report, they have no reason to lie about what you didn't go to or did go to. And frankly, they're a much more credible source of information than you are to me. So I believe them. And, you didn't go, you were referred to that outpatient substance abuse treatment on January 5th. And 11 sessions that you failed to attend. You didn't appear for drug testing on 4 different occasions, and then you did appear for testing on February 4th and tested positive. And you didn't make any efforts to pay any of the fines and costs. So really, what I see on paper is just no effort at all to comply with probation. No effort at all to use those resources to help you deal with your underlying problem or with the death of your father and how that would play into it. And you had those available to you. So to me, at this point, the whole purpose of probation and avoiding jail is to give you a chance to do those things. You've indicated through your conduct that you don't want to do that. So at this point, the option I have is to sentence you to jail. I think that's appropriate given the circumstances. Your original guidelines were 0 to 11 months. I think a sentence at the top end of the guidelines based on your total lack of compliance while on probation is warranted, both for the purposes of punishment as well as deterrence, so that other folks who are on probation see that if they're not going to try to comply, then jail is the outcome. So the court is going to sentence you to 11 months in the Crawford County Jail. You have credit for 68 days served. The court is going to order that you be unsuccessfully discharged from your probation and the 7411 status be revoked. The court will preserve any outstanding fines or costs. You do have the ability to seek an appeal of the sentence, and Mr. Thompson, you can provide those appellate rights.
So Ms. Leland, I'm gonna grab a pen. You're gonna initial these just to indicate that you received them. You're gonna walk away with 2 copies of this. You can decide if you want to file an appeal. If you do wish to file an appeal, use these forms to both file the appeal and obtain an attorney. Your first deadline is in 14 days. You're gonna wanna make a decision by then. Today's the 5th, correct, John?
Yes.
Thank you. All right. Ms. Leland has indicated as initial the top copy. She's gonna leave with the bottom 2. Thank you.
Leland, you already made it. That's the comments. Thompson, any other matters this morning?
I had Mr. Quack. I can check the lobby and see if he's arrived yet. Again, I got that message he was running late.
Okay, yeah, you can check, please.
Thank you.
If he's not out there, we're gonna go on record on that. Okay, we'll go on the record in People versus Quack. This is file number 265524. If I could have counsel put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Mark Quack.
All right, this hearing was set for 9:45. It's now 10:21 by my clock. Mr. Quack was not here today. Called for Mr. Thompson indicated that he did get a message from Mr. Quack, but he was running late. I see that he does have local address. Yes.
Yes, he's in town.
So, I don't think there's anywhere in Crawford County that you can't get to the house for a period of time. It's a nice day out, weather issues. So, the court's gonna note his non-appearance based on the normal practice of the court and the fact that there was some contact today. The court will set this for show cause, at its next date. So just notify Mr. Quack that, he needs to appear with a reason for why he didn't appear on time today. And that if he doesn't appear at the next hearing, we'll issue a bench warrant for arrest.
And just to help me understand, if he arrived shortly, is the court on the bench up or do you have to get back to that seat?
I am, yeah.
Okay.
I frankly just didn't want to make you wait around for Mr. Quack, so.
I understand your honor. I just,
Yeah.
sometimes I'll walk out and they'll be there. Thank you.
If he gets here, I'll be happy to take the case.
Thank you.
All right, our next hearing set for 10:30 with Mr. Scarboro. We'll take a short recess till then. Call People versus Scarboro. This is file number 235253. Mr. Scarborough is not present. It's my understanding that he is lodged in Wexford County Jail. So we did not have him available for today's hearing. So I would request that your office prepare a written document by video for hearing, which the court will set at its next available date. Mr. Thompson, anything on that case?
I just confirmed he is in Wexford. I did speak to him last Friday. I apologize for not contacting the prosecutor's office. I think this just slipped through, you know. I didn't do anything to ensure he was here, so I apologize. Thank you.
Okay, thank you. Next matter is People versus Wayne Barron, file number 265529.
Come on up here.
Sierra Coke on behalf of the people.
Thank you, Honorable Representative Brown. He's just making his way up to the podium.
Okay, we're set for a status conference in this matter today. Mr. Kermer, can you tell me where we're at with this file?
Yes, thank you, Judge. We're asking, we set this matter for trial. I would ask we set it down with plea cutoff and trial in about 120 days or so. Defense is going to request some experts in this, and I'm still get some motion to notice. She has to file. I think that's a reasonable time frame request to set this matter for trial at this point.
Okay. Ms. Koch, do you agree with the time frame?
Yes.
How many days of trial do you think we'll need?
Your Honor, we're going to have an expert. We're going to be doing a 768 and 404B on all three of his prior criminal sexual conduct convictions. I say that just so the court's aware. We're probably, if the court grants those, looking at 2 or 3 days. I believe defense is also seeking an expert. And it's sometimes hard to pick a jury on these type of files. So I think we can do it in 2, but we may want to set it for 3 just in case.
I agree 3 days, Judge. Defense has an expert, at least one at this point, and some of the witnesses will be duplicated from the people that intend to call. But it's going to be very fact specific, so it's going to take about 3 days, I think, Judge.
Okay, I'm just curious, what kind of experts are you calling?
Yeah, we're going to be calling the person that did the developmentally disabled, because this is a mentally incapable allegation.
Yeah,
So
I don't know anything about the underlying facts here, so.
the allegations are that Mr. Farron had sexual intercourse numerous times with a woman who was mentally incapable to make that decision. There's a developmentally disabled expert that did the evaluation in 2024. There's a companion DD case over in the other courtroom. So we're going to be having that expert to testify about her mental capabilities.
Okay, and then what kind of experts?
So we would intend to call a licensed psychologist. The incapacitated individual at the time was married to Mr. Farron. There was a legal marriage that occurred. So we would have a licensed psychologist do the evaluations regarding the IQ, regarding the capacity, regarding her mental capacity to consent.
Okay, so the defense is not that there wasn't
consent, correct.
Sexual intercourse.
No.
It's not going to be on the element of the capacity.
Correct.
Okay.
And her ability to consent and whether she was in that position.
Sure. Okay.
And then, of course, the court orders that were entered in the DD file and the requirements that order had would play into whether those were then followed.
Okay. All right. So Ms. Koch, I mean, do you have a time? Well, first of all, I guess my question is, you got some other acts evidence that you want to get in, so you're going to file notices for that.
Yes, we'll be filing those within 30 days, probably sooner.
Okay, so Mr. Gurmurthy, I mean, you're probably aware, but once those are filed, it's my view that for the defense to challenge those.
Correct. I'll file an objection and set it for a hearing. Correct.
Okay.
And I don't have, my understanding is there's about 3 or 4 different prior acts. I just don't have all that information. So that'll just take some time to get those reports and what the scope alleges, and then for me to respond to those.
Okay, so, but we'll need to have those hearings prior to that final status conference.
Yes.
And then, are you going to be challenging any of Ms. Koch's witnesses?
Lay witnesses?
Lay or expert? I just want to know if that's gonna be an issue that we need to address.
I don't think I'm gonna challenge the lay witnesses. I think from the information that I received in felony information, we would have the same witnesses. The expert, I believe that Ms. Koch is going to call us the same expert with the evaluation in the DD file. If that's the expert, no challenges there either.
Oh, and Ms. Koch, are you gonna be challenging their witness? Their expert witness?
They haven't had an evaluation done of Miss Bean that I'm aware of. I don't know who their expert is, what their expert's gonna say, or how they're gonna manage to get another DD evaluation done on a victim whose guardian certainly isn't gonna consent to another evaluation. So I imagine there's gonna be some issues in that regard. I don't know what they are yet because I didn't know until today that they were gonna try to get another evaluation done.
So there's two issues with that, and again, just full disclosure, my expert most likely would be Dr. Wayne Simmons out of Traverse City. I think he's testified in court before. Court's familiar with Dr. Wayne Simmons and his, and I'll get on a resume and so on.
I'm familiar with Dr. Simmons.
And that's who we're in discussions with right now. I don't have anything at this point. I don't have the funding approved by MIDC at this point, so that's in the works. I just spoke with Mr. Thompson this morning, again, asking about the funding. The verbal approval I got this morning was, yeah, no problem, but I have to have that in writing to get that funding to Dr. Simmons. So that's just the procedural behind the scene issues. It's not a delay on our part, it's just the paperwork that needs to follow through to get that.
Okay.
My intent is to have Dr. Simmons review the reports that the other expert prepared and conducted and work to that. If we need another evaluation, I'll certainly reach out to Mr. Thompson, who represents complaining witness in the matter. If we have consent to do another eval, we will. I'll come back to court with a motion. That's the plan, at least at this point.
Okay, all right. All right, thank you. I appreciate that. It sounds like this is gonna be not our usual case, so I want to make sure I understand kind of what the issues are so that we can schedule and stay on top of that so it doesn't delay the trial. All right, so we'll have the trial set for 120 days, 3-day jury trial. I will ask the council file any motions related to any of the issues we've discussed here today and get those set for hearing no later than the date of the final status conference, which will also be the plea cutoff. Any other dates, Ms. Koch, that you'd like to request the court schedule?
No.
Not at this time, Judge. Thank you.
Mr. Farren, do you have any questions about how we're going to proceed with your case?
No, sir.
All right, thank you. That's all for this hearing today.
Thank you, Judge. See you Wednesday. That concludes my docket for the morning.
Okay.
Thank you. Ms. McDowell, are you able to hear me okay?
I am, Your Honor. Thank you.
Okay, I should say, all right. We're on the record now in People versus Mallory Stapan. This is file number 245348. We have counsel for Ms. Stapan present by Zoom video, as well as the prosecutor present in the courtroom. It's 11 o'clock by my calendar, or I'm sorry, my clock. Ms. Stapan is not present here in the courtroom today. Ms. McDowell, I did have a chance to review your motion for guidance and the support for that. Was there anything you wanted to state for the record here today?
I would just add, Your Honor, that since the time I filed that motion, I've made several other attempts to contact Ms. Stapan by phone. There's no availability to leave a voicemail. It's either not set up or it's been full. I did mail her another letter as well, and I have heard nothing from her. So I don't have anything additional other than further attempts to make contact that have been unsuccessful, Your Honor. And at this point, I have to assume that Ms. Stefan is not interested in pursuing her appeal any further.
All right, thank you, Ms. Coe. Do people take any position?
I take no position.
Okay, so for the record, I'm well familiar with Ms. Stefan. She's been in my court a number of times on different charges. I would say, counsel, that what you've experienced with Ms. Stefan is entirely consistent with what the court has experienced with her in terms of processing her cases. She has a tendency to go back and forth on even very simple matters. This particular case, I recall the plea hearing numerous times. She indicated she wanted to accept the plea and then changed her mind, and then changed her mind again, and even throughout the course of the plea hearing, changed her mind on multiple occasions. So, counsels, excuse me, I'm trying to conduct a hearing here. If you guys need to talk, please go outside. I mean, is it not apparent that I'm on the record?
I know.
Yeah. Sorry, Ms. McDowell.
That's okay.
So I agree with the relief requested. I think what counsel's experience is consistent with what Ms. Fan has done in my experience as well. And so the court is going to consider that the appeal is abandoned. If there is any order that you need me to sign, I'm happy to do that if you'll submit that under the 7-day rule.
Your Honor, I did forward a proposed order to Ms. Cook. I'm not sure if she received that, if she had any objection to it, and I also forwarded it to Ms. O'Rourke yesterday for Your Honor's consideration. I'm not sure if you received that or not.
I'm sure it's at my office, so I will sign that once I get that.
Thank you, Your Honor. I will contact Ms. O'Rourke to get a copy of that signed order. Would that be the procedure then, as far as your court?
Yes.
Okay, and I will get that served on Ms. Stefan. And thank you, Your Honor, for letting me appear by Zoom. I appreciate it.
Of course, thank you. Nice to see you again.
Yep,
Judge.
good day.
You too. We'll take a short recess. File number 245280. The record should reflect Mr. Leland present here in the courtroom. Set for sentencing. Mr. Leland, have you had an opportunity to go through the pre-sentence report and talk to Mr. Vernon about that? Yes, sir. Mr. Vernon, are there any additions, deletions, or corrections to that report?
No, no.
Are there any challenges to the scoring of the guidelines?
So we had a, I don't think it rises to the level of challenge. We were just looking at the scoring of OB 19 on whether there was a basis for the 10 points that were scored. I did some research. There's unpublished case law on both ends stating that if simply providing false information to the police officer during the investigation, there were some cases that identified that it was appropriate to score or allowable to score, and some that said it wasn't. I didn't feel like there was enough information there to make that argument one way or the other, and it doesn't look like it changes the scoring, or that it doesn't change the guidelines. So
okay,
just wanted to bring it to the court's attention.
Okay. Thank you, Ms. Cope. Do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this one?
No, Your Honor.
Anything on behalf of the people for allocation?
You're right. I mean, the court's really familiar with this circumstance. I think we've already dealt with the other case with his co-defendant and his wife. The amount of meth in Mr. Leland's criminal history, I believe, supports the scoring the MDOC did, and the recommendation is appropriate. I'd ask the court to follow it. Thank you.
So, Your Honor, we would ask the court to consider something on the low end of the guidelines. You know, it seems that the recommendation for 12 years is a very long penalty. And Mr. Leland has a strong support system. He does have mental health problems that you know, I don't think contributed to this, but certainly will become a problem the longer he is lodged. So I don't know that I think if the court should consider, you know, the quality of life that he would be looking at if he spent 12 years with an undiagnosed and untreated dementia condition. So we would ask the court to at least consider those things. So yeah, we would ask the court to consider something on the low end of the guidelines.
Thank you, Mr. Leland. Anything you wanted to say today?
Yeah, I'm gonna attempt to read this. I apologize if it comes out.
Okay.
My decision that day altered and possibly ruined not only myself, but the lives of the people I hold closest to my heart. My 3 children, my 2 grandsons, and my wife. I hope this makes clear the choices we make in life not only affect ourselves, but our loved ones. I stand here and take full responsibility for my actions that day. I hope all that I have hurt or disappointed can and will learn to hopefully forgive me for what I have done. I'm truly sorry for my actions, but take complete responsibility.
Thank you. Mr. Leland, I did read through the report, so I'm familiar with the circumstances that bring you here today. I was already kind of familiar with it. Your wife's case was in front of me as well. So I knew kind of about the background facts from her pre-sentence report. And I certainly got more information about that from yours, as well as specific information about you and your background, your history, circumstances generally. I take all of that information into consideration to determine what's an appropriate sentence. Of course, I listened to what the attorneys have had to say. I listened to what you've had to say here today. And looking at all the information as a whole, this was an enormous amount. I think this may be the most in 13 years that I've seen an individual be found with. Usually we consider large amounts to be 50 to 100 grams range. We're found with 324 grams, indicating that you were well embarked on a large scale methamphetamine sale and delivery business. And so just the weight alone is going to result in a harsh penalty for you. Also, your prior record, of course, comes into play. The guidelines in this case are 87 months to 181 months. Before I even looked at the recommendation, my view was a sentence in the middle of the guidelines. was appropriate because I think the amount of methamphetamine that you were carrying justifies a lengthy sentence to make sure that you're not able to deliver that substance to people. It causes an incredible amount of harm to our community, and people are bringing it in, making it possible for others to purchase and use methamphetamine, especially to that scale. The court has a significant interest in deterring and preventing that kind of conduct, and your prior record certainly. I also think there are some mitigating factors like your health conditions, which prevent the court or convince the court that a sentence at the high end isn't appropriate either. And then I saw the recommendation, which is for 144 months, which in my view is pretty close to the middle of the guidelines. I think it's appropriate. I think it accounts for your conduct. I think it provides the community with some level of assurance that you're not going to be back anytime soon delivering this kind of bounce from methamphetamine to our community or any other communities. So the court is going to follow that recommendation. It says 144 months to 30 years in the Michigan Department of Corrections. You do have credit for 145 days served. Or will order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, a $68 state cost. You do have the ability to seek an appeal of the sentence. Mr. Vernon, will provide Mr. Leland with the appellate rights. And
we went over those before the meeting. You're going to sign the top copy. Or initial the top copy. I'll give that to the clerk. 2 copies to him, 1 copy to the prosecutor.
you are in the custody of the state at this time.
I don't know.
If they're ready, if not, they have.
Five-minute answers. I can see what
They're
you're
on
saying.
What the?
They're on their way in.
Oh. Is Deakons still in jail?
He is.
He is.
Yes.
Oh. Oh, he's got.
Yes, he is, and he will be until the 19th, so
Okay.
on a violation.
Okay, Mr. Robinson, are you ready? And Mr. Wakeley?
Ready, Your Honor. Good morning. Yeah, come on.
We'll go on the record in People versus Dale Wakeley, file number 255479. We're here in the courtroom today.
Sierra Coke on behalf of the people.
Your Honor, good morning. Nicholas Robinson on behalf of Mr. Wakeley's presence to my left.
This is the date and time set for sentencing in this matter. Mr. Wakeley, have you had an adequate opportunity to go through the pre-sentence report?
Yes, I did, Your Honor.
Mr. Robinson about it.
Yes, I did, Your Honor.
Mr. Robinson, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to this?
We do not have any.
Do the people have any additions, deletions, or corrections?
No,
Any challenges to this scoring?
no.
Anything on behalf of the people for allegations?
And I think the recommendation for 18 months is appropriate. I mean, the court's aware of the circumstances that led to the search warrant, that led to the possession. Mr. Wakeley has been at this for a long time. He's 61 years old. He has 3 felonies. He's been involved in some pretty egregious prior felonies. This history of dealing drugs and using drugs and going on this cycle is not new to Mr. Wakeley. His guidelines are 5 to 23. I think mid to higher end of the guidelines is appropriate given the circumstances. Thank you.
Mr. Mr. Robinson.
Your Honor, thank you very much. Your Honor, concerning Mr. Wakeley, and I know this might be a little bit of a stretch for this court, but I'm going to ask this court to consider a probationary term for Mr. Wakeley. This is a situation that Mr. Wakeley does come before this court. He does have a fairly high record. What we have here, Your Honor, and I think this is something Mr. Wakeley is going to tell you himself. We have a 61-year-old man that's coming before this court with substance abuse issues. That's what this is. And we have a pattern of Mr. Wakeley that whatever he has been doing with all of this, Your Honor, is simply not working for him. This is a situation where he's pled guilty to this. He has owned this. It looks like when he talked with probation, he did not make any attempts to sugarcoat this or anything like that. I should say that there is one part in here that concerns me about telling them that he was going to rehab, but it didn't. Turned out that he wasn't. My understanding is that he did try to seek help with Grace Center, I think that it was. They didn't take his insurance and it simply didn't work out for him. But this is a situation, as I said, to where as far as the substance abuse use, methamphetamine, I think everybody in this room knows that there's no white picket fences at the end of this road. And Mr. Wakeley is here and he will tell you that frankly, he's too old to be messing around with this stuff and wants the help, wants the chance. This is also a case, the set of facts, he had a gram of meth in his house. He was using it with somebody else in there. This is not good behavior, and he'll tell you that himself. But again, this is somebody that comes before this court willing and wanting the help to get himself right, Your Honor. He's fully employed. He runs his own carpet business, Your Honor. By all indications, he does an excellent job with this. And it's also my understanding this is a family business that he's continued for a period of years. So owns his own house, seems to be, to me, a productive member as far as being able to maintain employment, do good work for everybody, Your Honor. And with all of that being said, again, we're going to ask this court to consider a probationary term for Mr. Wakeley and allow him, not allow him, but almost help him get the help that he needs. Thank you.
Thank you, Mr. Wakeley. Anything you wanted to say?
Yes, Your Honor. I do own up to the fact that I was doing the meth and like Mr. Robinson said, I just want the help that I actually need, you know, because obviously I'm 61 years old and sick and tired of this. I felt like I put 10 years of my life from stress and worry. And I just feel like if I could just get some help and continue on getting help, that's my goal, is to stay clean. I mean, I'm bad with alcohol. I beat that. I've been sober on alcohol for over 10 years. And I just want to beat this too. I just want to continue getting the help that I need, if possible, if the court will allow me, Your Honor.
All right. I did read through the pre-sentence report, so I'm familiar with all the information contained within that report, both regarding the offense that brings you before the court here today, as well as just generally your background and your circumstances. So I take all of that information into consideration along with what the prosecutor and your attorney's done a good job of articulating the mitigating circumstances and positives about your circumstances. So I take all of those things into consideration when trying to determine what is an appropriate sentence. There's a couple things that stand out to me. I read your description in here where it indicates consistent with what you said here today, that you have an addiction problem, that you've been trying to get help and would like to get help for that. But I contrast that with what was reported from the Grace Center, and Jody Robson at the Grace Center said that you came in on October 14th, you did your intake form, and then you didn't come back, and maybe insurance was part of the reason for that, but more concerning is the indication that the defendant reported past drug abuse but denied any current addiction issues. So I'm not sure where the disconnect comes from when you're going to the Grace Center to get help and then tell them that you don't think you have an addiction problem, but then here you are today telling you that you have an addiction problem. So it's hard for me to know what's really going on with you, and hard for me to determine therefore whether or not you really want to seek treatment, or whether you're just looking for a lighter sentence or an alternate sentence from the court. The other thing that concerns me is the indication that there were multiple controlled buys conducted at your residence. So, which indicates to me that this may be more than just a use problem yourself and that you're selling. Even if that's to support your own habit, that would indicate that you're putting more of this substance out into the community and making it possible for other people to be abuse it, to be harmed by it. And so those factors all convince me that a sentence in the middle of the guidelines is appropriate. I think it takes into account all those things I've just stated, but also recognizes the positive factors outlined by your counsel. Your guidelines are 5 to 23 months. The recommendation is for 18. I think that's an appropriate recommendation. It's near the middle. And again, I think it accounts for all the factors here that I mentioned. So it is the sentence of the court that you will serve 18 months to 10 years in the Michigan Department of Corrections. You do have credit for 2 days served. The court will impose a crime victim's assessment of $130. Court costs of $325. A testing fee, $60, and a $68 state cost. You do have the ability to seek an appeal of the sentence. Mr. Robinson, next to you on the table there is Mr. Wakeley's appellate rights. If you can have him acknowledge receipt of those.
Does he just take this copy? Does he need to
He'll
sign
get
it?
it.
Does he need to
I
sign
get
it
the top
return?
copy, he gets,
Very
key
good.
back to him and when to prosecutor, please.
Some initials right here, Dale. I can approach your staff with a signed copy, Your Honor.
Yes, please.
So for the record, Mr. Wakeley has initialed his advice of, or excuse me, his notice of appellate rights. I'm handing that to court staff. Mr. Wakeley has a copy for himself.
Thank you, Mr. Wakeley. You are remanded to the custody of the state at this time.
Yes, Your Honor.
Is there anything you want me to take out? Can you give it to him?
No. Okay, yep.
Our next hearing set for 11:45 will be in recess until that time. I just want to make sure she knows about this here.
Oh, yeah, yep, and I like highlighted it on their copy, so they were aware of. But yeah, she came in, picked up, yeah, because they're circled.
Mr. Deakons, are you able to hear me okay?
Yes, sir.
All right, we're on the record in Harp versus Deakons. This is file number 2512034. The record should reflect Mr. Deakons is present by video from Crawford County Jail. This is a hearing on a show cause for a violation of a personal protection order in this case. This hearing was set for 11:45. It's now 11:52. I did check the file. The petitioner was aware of the hearing time today. The petitioner is not present. So Mr. Deakons, in order for the court to proceed against you, the petitioner would need to be present. She's, for whatever reason, chosen not to appear today, so the court is not going to proceed with the alleged violation, and the court will dismiss the violation. However, you are still subject to all the terms and conditions of the personal protection order. You had a question?
Yes, Your Honor. Is there any way, so I get what I'm at court today for, for the alleged violation, correct? I have my friend staying at my place in Gaylord currently, and he said that she's been driving through the parking lot, blowing the horn, throwing my property at my place, calling my work, trying to get a job where I work, trying to get me fired. And I get it's a toxic relationship, and I needed to hear this. So we try to make things work, of course, but things are just not going to work. And I want to be able to protect myself because this is all is going on because I will not pay her car payment and I will not pay her court fines. And it's just a blackmail thing going back and on. We're threatening each other back and forth, of course, and it's toxic. And I want to be able to protect myself as well. How do I do that is my question.
So that would require me to give you legal advice, and I might have to preside over that case at some point, so I can't tell you what to do or what not to do.
Yes, sir.
I would just advise, if you believe that your property is being damaged or destroyed, to notify law enforcement.
Yes, sir.
Do you have any questions about the proceeding today?
No, sir.
Okay. All right. So the court won't proceed any further on the alleged violation. That's all for this hearing today, and the court's going to.
Is there any way to, what do I got to file to get it rescinded, or what's that word I'm looking for? Rescinded, like to, I'm not sure if, I apologize. I just don't know what I'm talking about.
Sure. Again, that would require me to give you legal advice about what to do
Yes,
or
sir.
what not. And that's not my role, and it wouldn't be ethical for me to do that. So I can't tell you what to do.
Yes, sir. All right. I have no more questions, and I thank you for your time.
All right. Thank you.
Yes, sir.
All right. That concludes